Good afternoon, everybody. Is my up? No. Hello. Yeah. Good afternoon. We'll uh we'll go ahead and get started. I want to welcome everybody here today. I'm gonna take this off. Do that this time. I've asked Representative Lumpson if he'd lead us in a word of prayer, please. Thank you very much. Sorry I didn't get your mic on there. Well, welcome, everybody. We're going to go ahead and get started. We're going to do HB 640. We'll be reading LC 413064S, and we'll ask Representative Smith. He'll go right ahead.
Bring to you what is a substitute to HB 640 that I think you should have in your possession. The LC number is LC 413064S. And as I explained to you yesterday, I'll go through it real quick. There were some changes, and I'll speak with you briefly about those after I go through the bill. But Section 1, this is concerning Code Section 16-11-127. And what this provision would do is place our houses of worship in the same playing field as what other real property or private property owners would be in. Also, Section 2, this is concerning the issuance of Georgia weapon licenses and renewal licenses. This would provide that they accept those on first come, first served basis during normal business hours. And I know there may be some concern about that. What I was going to recommend, I spoke with the probate court judges this morning and yesterday about their concerns. I don't know if we have the language yet, but what I was going to propose to do, since they were worried about various different things occurring, what I was going to propose to meet some of their concerns about, the rush that they may have with people coming to apply for those licenses. What I was going to propose to this subcommittee is that we authorize our probate court offices, judges and their offices to go out and purchase a software program, preferably that comes here from the great state of Georgia, to provide for online renewal and applications, new applications for weapons licenses. I think with, what we've seen with COVID and what it's done to our court systems, we saw a lot of innovation. I think this would be a step in the right direction instead of having to worry about, long lines, facilitating those long lines, empower our probate court judges and their offices to have that software program, for them to go out and purchase a software program, kind of like we use with filing for court documents. You've got Peach Court in certain counties in this state. You've got Odyssey and other different filing systems, something similar to that, a software program that would help us facilitate this and cut down on wait times, hopefully, that we're seeing now. This would also provide for a private cause of action. If you have a probate court judge that is not doing their job, we have seen that in the past and concerned that it's still ongoing in certain areas. So if they're not issuing or accepting these applications for Georgia weapon or Georgia carry weapon licenses, then we have a cause of action to come and enforce them to do their job. So that's part of what that section does as well. What you also see in here is the database prohibition. I alluded to it yesterday as well. We do have prohibitions on multi-jurisdictional databases. What this does is also clarify that this applies to within a county area. What we have seen, when you find a loophole in the law, people get real creative. And what we have seen are certain, take for instance, a hypothetical here, the sheriff's office creating a database and then sharing that database with the county police, or even sharing that with the county public or county public health department. So this would prohibit that. They've kind of circumvented our rule there, and this would tighten that up and make sure that they're not still continuing to circumvent this. Also, you'll see in section 3, as I pointed out to the committee yesterday, we seem to have an issue in certain counties in this state, and I applaud the counties that do a great job on this, but we've got an issue with certain law enforcement agencies that are just sitting on large caches of weapons that they seize through different things, traffic stops, raids that they have to do. This would provide that they have to auction those off every 12 months. And this is not just somebody that would be able to walk into the sheriff's office and say, hey, I want to bid on that gun. They have to do it through a licensed firearms dealer who is approved under section 18 USC section 921. So these firearms dealers have to go through the requisite background check to even be able to be the intermediary, the middleman, so to speak, for our middlewoman for purchasing that firearm from these local agencies. And then section 4, you look at this is dealing with the defense of sovereign immunity. That would waive the defense of sovereign immunity concerning any claim, counterclaim, cross-claim, or third-party claim brought to courts of this state by an agreed person who would be trying to enforce the probate court, which had arbitrarily denied accepting applications for a Georgia weapons license permit. Section 5 would deal with a private property owner who chooses not to restrict lawful possession of weapons on his or her property, to make them immune for civil liability arising out of claims that they should have or could have restricted the lawful possession of weapons on his or her property. That's a key provision of the bill as well that I don't know that we parsed through quite as much yesterday, but I would submit to you that's very important for us. I would say this, you have in the law right now, if you use the situation of certain businesses that if it's a high crime area in certain circumstances, you know, if you could have done something or you should have or could have, you can be held liable. And this restricts that liability. So, and I'd be happy to answer any questions for the committee. We did take out certain provisions of this bill. We had some concerns that we wanted to work through. You know, as we know, we always have next year, good Lord willing, to come back and work on those. But we had a little bit of a heartburn issue with some of the municipal ordinances that we would be preempting. And so in order to address those and to give us a little time to work on that, we took that out of the bill. The emergency powers, I know the governor's office had some concerns about that, and we had to take that out of the bill as well. And so we can examine those concerns as we go forward. But I'd stand for any questions from the committee on this.
All right, thank you, Representative Smith. Do we have any questions?
Oh, and one other thing, I know Representative Holcomb yesterday in full committee had asked about actual damages. We actually changed that to general damages. It's not necessarily a huge difference there. It's just making that uniform with what the other Georgia Code section concerning damages would read. So we wanted to make that uniform so our code revision committee doesn't have to go back and correct this for us.
I do believe we have somebody to speak to the bill that's online on Zoom. We're going to go ahead and go to that. John Monroe,
Yes, I'm here, Mr. Chairman.
will you go right ahead?
All right, thank you very much, Mr. Chairman and members of the committee. My name is John Monroe. I'm the Vice President of GeorgiaCarry.org. I refer to it sometimes as GCO. GCO is a several thousand member organization devoted to fostering the rights of its members to keep and bear arms. I'm here to testify in support of HB 640. I appreciate Representative bringing the bill. Before I begin, I want to address some of Judge Wolk's comments to the full committee yesterday. I have a lot of respect for her. I've known her for many years and worked with her on many cases. She told you that it's well settled that weapons carry licenses are not the same as Second Amendment rights, and people don't need a license to exercise their Second Amendment rights. I disagree with that. In order for a legal issue to be settled in any meaningful sense, it has to be decided by at least one appellate court. For something to be well settled, it would have to be decided at least a couple times to make sure there's no room for disagreement or any nuances. And in the case of licenses and the Second Amendment, there's no appellate case law at all in Georgia saying that a license is not needed to exercise those rights. And I'll tell you why I think there is. First of all, the Second Amendment has only been interpreted in the modern sense since the 2008 landmark decision of District of Columbia versus Heller. In Heller, the Supreme Court of the United States ruled that the Second Amendment protects an individual fundamental right to keep and bear arms in case of confrontation. And the court also ruled that the handgun is the quintessential arm for self-defense in the United States. And then the court ruled in 2010 that the Second Amendment applies to the states in the city of McDonald versus City of Chicago case. And the Supreme Court of Georgia has ruled in 2013 in Ferguson versus Perry that the right to keep and bear arms is a civil right. So between the state and the national high courts, it's well established that the Second Amendment is on equal footing with other important fundamental rights like the right to free speech and the right to free exercise of religion. Now, Georgia is only one of 15 states that even requires a license to carry a handgun openly. And handgun, like I said, is what the Supreme Court's ruled to be a quintessential arm for self-defense. Under OCGA 1611-126, a person has to have a license to carry a handgun outside one's home, automobile, or place of business. And even then, OCGA 1612-127 makes it a crime to carry a firearm even in one's own automobile within a reasonable distance from a bus stop without a license. A violation of that particular law is a 20-year felony. So imagine a scenario where the law required you to have a license to worship unless you were in your home, automobile, or place of business. Would anyone for a second claim that the worship license did not implicate the First Amendment? I don't think so. To claim that the Georgia weapons carry license does not implicate the Second Amendment is to fail to recognize the importance of the Second Amendment right in the first place. Now, if Georgia is going to require a license in order to meaningfully exercise the Second Amendment right, then the license has to be available within a reasonable amount of time to all the citizens who are eligible for one. And that's the issue with Section 2 of the substitute Representative Smith was going over. In order to understand where we are today, it's helpful to look at the history of 1611-129. Back in the mid-2000s, that code section required a probate judge to issue a license to an applicant within 60 days if she found the applicant to be eligible. And we had an applicant who had waited several months for a license, and he sued that probate judge to require her to issue the license. And he lost. The Court of Appeals affirmed, and they said that the probate judge could wait as long as necessary to determine if the applicant was eligible. So then GCO went to the legislature and asked to have the law changed, and it was changed so that the judge had to issue the license unless she found the applicant to be ineligible. And so that means that the judge had to follow this statutory timeline and couldn't just delay forever if there were questions about the applicant's background. So then what happened is probate judges started suspending processing of applications in order to create additional time for themselves to process applications. And that was beyond what the statute allowed. So we came back to the legislature and asked for a law to prohibit suspending processing of applications, and you passed a bill to do that. So that puts us in a situation where today the probate judges must issue a license within 10 days of receiving the background check, unless the probate judge finds the applicant to be ineligible, and the judge is prohibited from suspending processing of the application. So where that leaves us is sometimes probate judges will just deny an application because the deadline's coming, and then leave it up to the applicant to prove otherwise. But the law has a remedy for that. The applicant can sue the probate judge in mandamus if the applicant thinks he's eligible, and if he proves he's eligible, he's entitled to the writ and gets his license. And in fact, I am a practicing attorney, and I have to bring several of those cases a year. I probably have about 10 such cases pending right now. But we do have a provision in the law to address it, so that works. What happened then is after COVID struck, the Probate Judges Council determined that issuing weapons carry licenses was a non-essential function, so they just stopped doing it during the first several weeks of COVID. And I think Judge Wilk mentioned that yesterday. And they did that even though the license is needed to exercise that individual fundamental civil and constitutional right that I talked about earlier. So what we did was I asked the governor to use his emergency powers to suspend the application of 1611-126. That's the provision that requires you to have a license, but he declined to do so. So we asked the Chief Justice to declare that the licenses were essential, but he didn't do that either. So what we did then was brought a few mandamus cases against probate judges in some of the larger counties, saying they can't just stop accepting applications. Before the case actually got decided, or cases actually got decided, they started issuing them again, and all the cases got declared to be moot. So that's where we are today. We still have the larger counties requiring appointments in order for applicants to apply. Judge Wilk mentioned that yesterday. I mean, she testified yesterday that she had no idea how large this backlog is that was created. But the reason she doesn't know how big her backlog is if you recall, she said yesterday that she only opens up appointments for 30 days at a time around the 23rd of each month. So on the 23rd, they open up on their website a block of another 30 days worth of appointments. What I'm told by people who call and complain to me about it is, unless they get on quickly, they can't get an appointment in that 30-day time frame. So then they just have to wait till the next month when another 30 days gets put on there, and that can go on for months and months without a person being able to get an appointment just to apply. Imagine if you had that situation with your doctor. You called to make an appointment for a checkup, and the doctor's office said, well, we don't have any appointments for the next 30 days. If you call us back next month, we'll see if you can get one then. And that could go on and on forever. What people do when they're depending on their customers for their living is they have a system where you can make an appointment as far into the future as necessary. But apparently the probate judges aren't doing that. So they don't know how big the backlog is because they only let 30 days at a time. I don't know why they do that. It seems to me what would make sense is to let people set up their appointments for as long as they need to. Now, HB 640 doesn't do anything really radical. What we're looking for is just a provision to require probate judges to accept applications on a first come, first served basis. It sounds like they're resistant to that because they can't accommodate everyone who wants to apply for a license. I think Judge Wilk testified in her county, Cobb, they expect to handle 20,000 applications this year. And that's about twice the number of the applications that she processed for the last year that her office reported their stats to the Administrative Office of the Courts. Now, there's currently about 1 million residents of Georgia, citizens of Georgia that have a weapons carry license. If the application rate doubles on a statewide basis, which apparently is what's happening, that would mean we'd be in a situation with about 2 million people having licenses out of a population of 10 million. So that's roughly 20% of the population. If 20% of Georgians want to exercise a fundamental constitutional right, and they have to obtain a government license in order to exercise that right, the state has to create a system whereby they can get a license within a reasonable amount of time. If that can't be done, it might be time just to discontinue the requirement to have a license. Like I said earlier, Georgia is one of only 15 states that even requires a license to carry a handgun openly. And we're up to 18 states now that don't even require a license to carry a handgun concealed. If the probate judges are telling us that they can't accommodate the volume of Georgians that want to apply, it might be time in the future at some point to look at even requiring a license. But for now, all we're asking for is the simple fix of requiring probate judges to accept applications on a first come, first served basis. I'm happy to answer any questions on that. I didn't address the other provisions of the bill, Mr. Chairman. I think we're down to the other provisions not being particularly controversial. I don't believe there were any or many at all questions from the full committee yesterday on the other provisions, but I'm happy to address any provisions of the bill if anyone has any questions.
Well, thank you for those comments, Mr. Monroe. Do you have any questions for him? I don't see any. I do appreciate you very, very much. Thank you.
All right, thank you, Mr. Chairman, members of the committee.
Yes, sir. Thank you. Next, we'll go to, I believe it's Mr. Stephen Lofton to speak to the bill.
Mr. Chairman, I represent the same organization Ms. Monroe does.
Uh-huh.
He's covered. Thank
So
you.
you're good. Okay. Thank you very much. All right. We have one other, Thomas Weaver. And if we could kind of keep these brief, we got 3 more bills and a bunch of folks to talk. So thank you. All
Yes,
right.
sir. Yes, sir, Mr.
Yes, sir.
Chairman. Thank you. Allow me to introduce myself to the committee. My name is Thomas Weaver. I've been a staunch, strong gun as far as proponent of legislation in this matter over the years here at the General Assembly. I did have various different remarks that I was going to submit. However, having had the opportunity to read the substitute version of the bill that has been presented by the author, I'll cabin my remarks not only for brevity, but also to match what's actually the sustenance of the bill itself. The only thing that I'd like to bring to the attention of the committee is under Section 1 of the bill, where you venture to repeal the statutory prohibition against carrying a weapon or long gun in a place of religious worship. That code section has bifurcated punishment provisions. So if the General Assembly sees it fit to repeal Georgia Code Section 16-11-127, subsection B, paragraph 4, then further down in that code section under subsection E, paragraph 2, that would also have to be removed, because that subsection in that paragraph provides for the punishment for a violation of B4. If B4 is gone, then E2 under the same code section would have to be removed also. But that's more of Scrivener, and I'm sure that that's not anything that Legislative Council can't fix. I did have other remarks, but again, based on the request of the chair, I'll keep my remarks brief, and thank you for allowing me to speak.
Well, I appreciate it. I think I got some of that.
Right.
So we'll have to check into those codes.
Right. Basically,
yeah.
the whole code section, if you repeal the crime, then you
Yes,
have
sir.
to repeal the punishment. that matches.
We'll talk to Representative Smith and we'll see where we're at on that. But I do appreciate you coming in. Are there any questions? I don't see any questions. Yes, sir, Chairman Powell.
I'd just like to make an observation. I read the section too, and one of the issues that we've been dealing with that's been giving everybody a lot of angst and heartburn has been the problems about the issuance of a concealed weapons permit. And a lot of this, as we heard the testimony yesterday from the probate judge from Cobb County, it is just a tremendous backlog on this, because a lot of it's because of the virus, but I think it's maybe even goes further than that. That they've just been inundated by the number of applicants. Now, I'm not don't want to make any excuses around that, because I certainly believe any and all people have that right to reach out for that concealed weapon permit. As I'm looking at the language here, and as John was getting into his normal lawyerese and legalese into that, there might be a simpler way, if it's the will of the committee, that in listening to that discussion yesterday with the probate judge, that possibly, and I touched on it yesterday, would be maybe to put language in there that if you're a legal citizen in the state of Georgia and that you are legally eligible for a license, that if you can't receive that license within the number of days required, then, or the application is not being processed, then allow them to go forward. And if they're eligible under Georgia law, and they could be given a statement of no felonies, no domestic violence charges and whatever, then they should, if they're living within the terms of this, of the concealed weapon permit, that they should be able to carry that permit, or they should be able to exercise their rights. Now, that's just a thought. If this thing gets bogged down in the weeds on, of how to deal with it. I know we've even talked about putting language in here to allow them to do a database, or to not a database. God forbid, don't let me utter the word database in relation to a license, but to sync up a digital or computer system or something to help process these licenses, as long as there's no database being created.
Any comments on that? Anybody? I got another question. Thank you, Chairman Powell. Number 16, is that you, Representative Jasper?
That's
Chairman Powell, go ahead.
yes, that's Chairman
Collins,
Collins.
excuse
Yes,
me.
that's all right. I know
guess-
I
my
resemble.
bad.
I know I
You want to be
resemble
Chairman Powell.
I know I
understand
resemble the
that.
chairman a good bit. I think Chairman Powell is spot on with his comments about the licensing. One thing that's frustrating to me is that, I come from local government. I spent a good bit of time in local government, and God bless them for what they do. They're good folks. But if you look and see how much money has been poured into government, local government, because of the pandemic, I think we can all agree on that. And if you can't get your job done between Monday and Friday, what's wrong with working on little Saturdays every once in a while? The money's there for these people to be able to pay folks overtime to help alleviate the caseload. And for the life of me, I can't understand why that's not being done in some of these situations. I come from the private sector. I'm a small business owner, and it's very frustrating when you hear, well, we can't do it. Well, can't never could. And so, my message is, if the probate judges are listening, I know a lot of them around this state are doing a great job, and there's some bad actors out there, and they need to be dealt with. But for the love of God, please do your job so these people can get a concealed carry permit at a time when you probably need it the most. But I echo the chairman's comments about the backlog, that we need to do something to allow folks, if they can't get that permit, to allow them to exercise their constitutional right and carry a weapon. Because the alternative is, if you have people that are carrying long guns to Walmart and Quick Trip, that's going to cause another issue there. And then we're going to get blamed for that. And that's not our fault.
Thank you, Chairman Collins. Any other comments? Representative Smith, you want to comment to any of those?
Thank you, Mr. Chairman. I appreciate both of the chairman's remarks on this. I'd be open to that, whatever the will of the committee is, to amending this. Bill, I know we've changed it up a good bit within the last 2 days. I've learned just how quick we can move, which that's a testimony to the Georgia State Legislature, I'll have to say. But I would be amenable to that. At the end of the day, if our government's failing us in facilitating us being able to exercise this right, then we need to fix it. No holds bar. I mean, I will tell you this, when I was served over here as a legislative aide years ago, I can remember I rode out through Georgia State. And I think this was the time that Chairman Jaspers and Chairman Powell and some of the others were carrying the gun bill back then. And saw this young lady, and she was walking with a big old stick. I mean, it was good size. It probably, when you think of Moses' staff in the Bible, that's how big this sucker was. And she had it toting it horizontally. And it didn't take me but a split second being out from West Georgia in the country to know what she had that stick for. And I just thought how humiliating it must be for a young lady to have to tote that big old stick around on that campus that has had a history of violence and muggings and robberies at gunpoint. And she's left with nothing but a gun to defend herself. So I have seen, I know many of the members of the committee have seen just the sort of issue that not issuing, that the backlog or the lack of processing and getting these weapons licenses issued, it has a real world effect. So I'd be open to the committee providing them with the authority to get the software. Give them that authority. I don't want to tell them which software to get, because that I think, that's one of them local control things. I still want to give them the opportunity to make that decision on what software program to help facilitate the intake of both new applications and renewal applications.
Thank you. We got any more discussion on that? Yes, sir, Chairman Powell.
After consultation with my partner in crime over here and the chairman of the full committee, to hasten this out at the, if it so be the desire of the committee members, if they would feel free to move this substitute forward, then we're going to have some amendments in the morning that would be prepared. One would be to authorize the probate judges or the probate judge council or whoever to move forward with whatever programs they so desire, to set up a process for appointments and all of that. But in the process to that, we'd like to prepare some language for the rights of people, that if they can't go through that because of whatever purpose, if they can't get that concealed weapons permit, that they would be allowed, if they are eligible, to have the same rights as a person under that concealed weapon permit, with the exception of the fact, without that, they can't go to a firearm store and be bypassed from the standpoint of the 72-hour wait. But they could carry it in the same places allowed under current Georgia law if you have a CD weapons permit. Take the burden off of it. Let's just cut it to the chase, and let's take the burden off the probate judges. I'm not blaming probate judges
Understand?
for the job that they've got to do, because, in this day and time that we're living in, we have a tremendous amount of people, numbers of people who want to exercise their rights. We're living in uncertain times. They saw the events of this past year. We see this, the actions of this house today. We've just passed the House version of a law for people coming on their porches and, stealing porch stuff. We're living in difficult times.
Yes.
And this is a reaction to the people of this state. And if they're legal, bona fide people who meet that authority, just because they can't get that license when it's due, then they need to exercise their rights and move forward. There's just a few things they can't do. And one, and the most important one that I think about under a legitimate concealed weapons permit, and that would be able to take that as a form of ID to a gun store. But if they've applied for it, they'll get that in someday. whether it's 2 months, 3 months, or 4 months, and, but, I don't want to blame the probate judges. But let's just cut to the circuit. If they can't get it done, then let's put another venue out there while they're trying to get them done. And let's make it a lot simpler. I'm not blaming them because, everybody is just, we're living in different times. So let's just get to another venue to it, make it a lot simpler. But, I always tell folks, it takes 91 votes in the House. And there's got to pass the Senate. So let's put some legs under this thing and let's get it moving. And we've got a full committee tomorrow. And if with the permission of this subcommittee, I move that we pass a substitute along with full knowledge that we will have some language with Representative Smith ready for the full committee tomorrow.
Thank you, Chairman Powell. I agree with you 100%. I think we need to keep this moving. I really do, because it is that important. I agree with 100%. Any other questions on that? Any discussion on it? All right, we have a move, we have a second. Let's vote. All in favor of moving this along, say aye. All opposed? He carries. Thank you.
Thank you, Mr. Chairman, and
Representative.
members of the committee.
All right, we're gonna move right along. We're gonna go to, I'm sorry. We're gonna go to Representative Bonner. He has another engagement he has to be to. So we're gonna go with HB 534.
All right, thank you, Mr. Chairman.
Let's see, I got it somewhere here.
We're working off of LC 392981-ECS. After meeting with the chairman and getting some feedback from some folks, we did make a few changes to the bill. Those changes, there's one we didn't catch that we'll accept a friendly amendment to, but the majority of the changes are in section 6 of the bill, starting back on page 13. What we did with those fines and punishments is to match those very closely with the DUI statutes, so that those are more in line with that rather than what we had proposed yesterday. So those really, Mr. Chairman, the only changes to the bill. Be happy to take any questions that you might have.
Do we have any questions? Yeah, we do have one. Maybe Chairman Collins.
The only thing I see here is I believe that was on line 46,
That's correct.
where it says shall be 12 months. So we wanted to do up to 12 months.
That's correct. That was submitted, but that was my error for not catching that.
Should be up to.
Up to 12 months.
Okay. Any other comments on that?
We did make all the rest of those changes we discussed.
We did.
yesterday.
In particular, the other one that we discussed is, you'll find that on line 318, Mr. Chairman.
Okay. And just, if I may, Mr. Chairman,
Absolutely.
one of the reasons why I met with the author of the bill is I certainly don't want someone who commits this offense one time to have the whole courthouse thrown at them. I think that's very important to give some grace. Second and third and repeat offenders, obviously, you need to get their attention. But a first offender, some young person who might be out on the road doing something they shouldn't do, doesn't need to have their criminal record ruined, but because of bad judgment at an early age. So I appreciate the author working with me to get that straightened out. I think that made this bill much better, and I really appreciate that.
Yeah, thank you, Mr. Chairman. And I would like to point out that what that does, and as we match that DUI statute, it does push that asset forfeiture to another step. So there's one more conviction required in order for that to happen. So
Thank you.
Any other questions? Any other comments? I believe we have two folks to speak on this. Just Maisie Causey. Is she online?
Hello, Chairman, I'm here. Can you all hear me?
Yes, ma'am, Ms. Causey, you go right ahead.
Thank you, Chairman Collins. And thanks for hearing from us again today. I know not everyone was able to be at the full committee when we spoke yesterday, but I'll keep my comments brief. I have not had a chance to review the new substitute, but I do appreciate what I'm hearing about the reduction in the punishment scheme, and I look forward to seeing that as it publishes overnight. I especially appreciate your concern there about the first convictions, Mr. Chairman. That's quite a grace. Even with the punishment modifications that have been alluded to here today, the issue of enforcement remains a concern. At full committee yesterday and at earlier stakeholder meetings last year, law enforcement have opined about how elusive enforcement is for them, given the transient character of these activities. GACTL continues to find that criminal code expansion is an ineffective response to what is an enforcement shortcoming. This is one reason why we continue to encourage the consideration of establishing a study committee to discover ways to mitigate participation in these activities, especially those that threaten public safety. For instance, in other communities, they've realized success, as I mentioned yesterday, with things like streetscaping, which impedes the use of roadways for these activities. There are also more formal programs like one called Beat the Heat, which is a really innovative program that was founded back in the 90s by first responders to help combat the problem of street racing. Beat the Heat is a national organization that is comprised of police officers and firefighters who conduct educational programs they use marked emergency vehicle drag cars. And part of their work is to educate the general public about the sport of drag racing and encourage racing in controlled environments with emergency personnel on site rather than in public streets. And these are the kinds of ideas that could come out of conversations among stakeholders at a study committee. Even as this bill goes forward, we would still encourage this committee to consider a study committee so that there's a possibility of finding some more innovative ways to address these concerns short of criminal involvement. We do continue to have concerns, no matter, even if the punishment scheme lines right up with DUI, we would still suggest that there could be a challenge under the 8th Amendment based on the 2019 case out of Timms. I'm sorry, out of the United States Supreme Court. It's called Timms versus Indiana. In that case, the court suggested that forfeiture of Mr. Timms' vehicle, in that case, it was a $42,000 vehicle, was disproportionate to the felony crime in the case that carried a maximum fine of $10,000. And because HB 534 subjects certain vehicles to forfeiture, we believe this provision will be ripe for challenge under Timms. Moreover, this forfeiture, what's that? I'm sorry? Was that not for me? Okay, I just have a couple more sentences.
No, I think it was something else. Go ahead.
Okay. The forfeiture scheme that's contemplated involves, does not require the actual involvement of the vehicle owner in the alleged offense. So the forfeiture could happen even if the owner was not the operator of the vehicle. So a person could find her vehicle subject to forfeiture without having participated in any fashion. And the escape valve provision does not cover that necessarily. It's an issue of hardship for a family. So in closing, I would just say that given the enforcement concerns that have been expressed continuously and repeatedly, that there are other ways that should be considered to try to mitigate this problem. I will be surprised if expanding the criminal code actually leads to a reduction in these activities, and really would encourage you to gather stakeholders and have some productive conversations toward innovative solutions. Thanks for hearing from us again today. We really appreciate the time.
Thank you, Ms. Collins. We appreciate that very much. Does anyone have any questions for Ms. Collins? I don't see any, so.
Thank you. No problem.
Any of the committee members have any questions? Any comments? If not, let's, I'll take a motion. I have a motion to do pass. Do I have a second? I have a do pass and a second. All righty. All in favor, say aye. Excuse, all right, do the amendment. You got a question? We got one?
Yeah, we could do it after that. When we get to discussion, I just want to ask one question.
Yeah, go ahead. Go ahead and ask that question.
Okay. Thank you, Mr. Chairman. Representative Bonner, I know we had talked about this earlier about the changing of the penalties to more coincide with the DUI penalties. I don't see anything in here. Before there was it became a felonious act after the third offense, I believe, in the previous version. Is there anything in here where this person will be declared a habitual violator and subject to felony with a vehicle after that?
Yes.
Okay. I'm sorry, I didn't see it. I hadn't had time to run through the
Yeah,
whole.
that portion
substitute.
didn't change. No.
Okay. All right. Thank you.
I think it was my bad. I think we got to go back. Was that on line 46, Chairman? That we're going to do the amendment. Do I have a vote for the amendment to change that? Go ahead.
I'd like to make an amendment on line 46 that we strike B and we add two words there, up to
Okay.
12 months.
Maybe
Yeah,
just
on-
leave B and then add those two
Strike
words,
B
Mr.
and
Chairman.
put up to. Is that
Yes, that's right.
correct,
That's
Chairman?
exactly, I'm sorry. Yes, that's exactly right.
Okay.
Leave B. We don't
Okay.
want to take B out.
Okay. Leave B and put up to in there.
Yes,
Up to 12
up
months.
to 12 months.
That's right. I have a motion. He makes that in the form of motion. We have a second. We have a second. All in favor, say aye. All opposed? Amendment carries. All right. Any other discussion? Now we had a motion to do pass in a second. Can we have a motion on the bill? We'll do that again since I got a little out of track there, so we'll get straightened back out. To the substitute of this bill 534. Do I have a motion? I have a motion. Do I have a second? Have a second. All in favor, say aye. All opposed? Motion carries. Thank you, Representative Bonner.
Thank you, Mr. Chairman, members of the committee.
That was weird. All right. Mandy, you okay? Can we go with Mr. Hitchens, be okay? Representative Hitchens, Chairman Hitchens, if you want to go.
Mine's gonna be a little lengthy, I believe.
Well, how about yours? Well, why don't we do this? Let's do this for Representative Ballinger and let her, she said hers is going to be short, so we're going to trust her at that. You could have done it from right there. It'd been fine. Okay.
Okay, ladies and gentlemen of the committee, I present you House Bill 368. I am working from LC 41306-5S.
Yeah, I saw it.
Okay. Can somebody mute themselves? Okay, thank you.
Yeah.
If you, obviously, just to reiterate what I'm sure the chairman has already said, if anybody online would like to be recognized, just raise your hand and I'm sure he'll be able to recognize you for a question. So House Bill 368, it just basically gives original jurisdiction for the investigation of any child under the age of 18. It gives original jurisdiction to the Georgia Bureau of Investigation. It is supported by the GBI. As anybody who has ever investigated a death, there are a lot of specialized nuances with regards to children that are necessary for a thorough investigation and conviction. Some of those were kind of falling short throughout the state. So in order to ensure that we, even though we have failed the children in their dying, at least we can get them justice after they pass. if it's thoroughly investigated and we're able to, that results in a conviction. So that is the bill in a nutshell, and I'll be more than happy to stand for any questions.
Do we have any questions? We don't have anybody online. Yeah, okay. Yes, sir. Go ahead, Representative.
Thank you, sir. Representative Ballinger, so you said this would give original jurisdiction to the GBI, so they would be the primary investigating agency for any child death under 18
Yes, sir.
or any crime involving Title 16, Chapter 5.
Well, any murder, including, I believe it includes voluntary manslaughter.
Okay, because it just says, yeah, Article 1 of Chapter 5. Okay, thank you.
Yeah.
I'd spoken with my sheriff and a couple other folks in local law enforcement. And so part of my background, I was an investigator with the Henry County Police Department. And I know that at times we had a larger staff that was more able to investigate some of these crimes than the GBI. And I know speaking with some folks with the GBI, that they have had a concern that one of their biggest backlogs is with their medical examiners. So that would be my only concern, is that if whether or not they have the resources and the staff and the ability to investigate these, if they take original jurisdiction away from a local department. I know there's a lot of them that don't have the resources to do it, but I'm concerned if they do take it from a larger department that may have some of those resources dedicated to the special child investigative unit, that might be less effective for the family of the victim. So did they?
You know, unfortunately, you can't contemplate everything. And I do give, I believe that GBI enjoys original jurisdiction on a lot of different drugs, that sort of thing. That doesn't mean they're the only ones that ever take arrest warrants for drugs here in the state of Georgia. But it is contemplated that if there was a perception of sufficient resources, particularly in some of our more metro areas, that there would not be a relinquishment. The investigation would be handled by the quote unquote the locals, so to speak. But just to give that, as you know, as a criminal investigator, those first 24 hours in any investigation are just crucial. We had a horrific crime in Cherokee County. Former Director Vernon Keenan, y'all might have heard about it. It was a little girl who went missing. It was a guy who was a very bad guy who had done it, who'd been living in the apartment complex with her and her family. But long story short, he was ultimately convicted of that crime. However, my chief of police, whenever he first got there, in the mobile incident unit van that was there, that's kind of the mobile command center, shall we say, his first words were, "What channel's the game on? Let's get it going." And so that investigation actually, Director Keenan actually lives very close. He's a constituent, lives very close, and was able to step in and ultimately get justice for that child. So that's the whys and wherefores thereof. It's not meant to step on any toes or anything. I've always, obviously coming from a prosecution background, I've always been very supportive of our law enforcement community.
Any other questions? I believe we have, oh, I'm sorry.
No, it's fine. Just one last comment. Thank you for that. And I wanted to reiterate too, that I've had an opportunity to work with the GBI in several different cases, and they have always been very, very supportive and very helpful. And I didn't want to in any way diminish their abilities or question their abilities, just the resources, and make sure that we don't have, I'm sure that they will, do what's best for the victim. And if the local agency has the most resources, then they'll allow them to continue the investigation. I just wanted to make sure that that I asked that about whether or not they had the resource to handle it. So
Yes.
Thank you.
Chairman Pop.
Thank you, Madam Chairman. I'm sitting there trying to work my way through this, and I know that the Sheriff's Association has reached out to me. I think they've even been here, and as a matter of fact, I've had all three of my sheriffs and several other sheriffs from my days up here chairing this committee. There you go. And has there been any discussions? Have you had any discussions with them? I know that the sheriffs have been very concerned about giving another law enforcement agency the rights to come into their county where they are the number one or supposedly the base of the law enforcement in the county. But have you been able to have any discussions with them, the Sheriff's Association?
I've obviously talked to my own sheriff about it. I have several friends that are still with the SO in Cherokee. So I've obviously spoken with them about it. I always have had an open door policy. I've served on public safety, not public safety appropriations. I have served on public safety appropriations, but also have served on judicial non-civil and have a good relationship. And nobody has mentioned anything to me. I've always had an open door policy and nobody has mentioned anything to me about the bill. If there are any concessions that they would like, if there's any, obviously, me, I'm willing to work and make everybody comfortable, and nobody has reached out to see what accommodations might be made to make them more comfortable with the proposition.
Thank you. We have any other questions from the committee? I think we have, Ms. Causey again on Zoom is going to speak to the bill.
Thank you, Chairman. And it might just be as simple. I'm sorry for the pandemic need to be at home. I've been on school supervision duty today with virtual schooling for my child. So I was not able to come to the Capitol, and I appreciate the accommodation, but it makes it difficult to see the language of the bill. And we'd spoken with Chairman Ballinger about some of our concerns. And I just would love to be able to confirm whether or not the subpoena power that was included in the original filing has been maintained in the substitute, or if it has been removed. That was really our only concern.
I don't see it.
Okay, thank you.
No.
Thanks so much. We have nothing else.
I would sing, but y'all would pay me not to. So. Actually, that might be a good way to get some money. Pay me or I'll sing.
I'm sorry, I just had a question.
That's certainly all right, Mr. Chairman.
Sometime, is Ms. Causey, is she completed her?
Yes.
Okay, and you answered her? Okay.
Yes, sir, I did.
Representative Ballinger, I was just curious to one thing. I'm aware that Georgia has a child fidelity review committee board in each county.
Yes, sir.
It's run by the district attorney of that district in each county.
Mm-hmm.
And anytime we have a child death, and that's considered at anything under 18,
Yes, sir.
it goes under, there are a great number of folks involved, whether it be a natural death or an accidental death. The only thing that keeps that from being investigated like that, if somebody had a terminal illness, if some child was born, with a say cancer or whatever kind of type of affliction. So I'm just somewhat curious why we want to make it automatic to go to the Georgia Bureau for any homicide under, because they are already investigated to the hilt anytime it's a minor like that, or a youth from child is from. So can you just elaborate on that to me?
I'm happy to elaborate. I'm trying to be delicate and not step on toes.
Sure.
Just like I used my own example in Cherokee County. I do know, just as a little background, I sit on the state child fatality review board and have sat on the child fatality review boards of 2 separate counties. So I've investigated those deaths. I've reviewed those deaths both at the county and at the state level. So I'm well aware of a lot of the child investigations that go on for these deaths. And I will say that there's just a level of expertise that the GBI can bring to an investigation such as this. They have, child anthropologists, archaeologists, they have things that you're just not going to be able to see. And as anybody who's been in law enforcement is well aware, it's that first 24, 48 hours that is just so crucial with the gathering of the evidence. If you have, say, some children have been buried in the backyard and somebody gets back there with a skid steer and starts digging them up, that's going to irrevocably harm any kind of evidence and any hope that we had of getting those children justice. And so that's why, bringing in, those with subject matter expertise first. We're certainly not trying to tell somebody how to run their investigation, but as a state, we have an interest in making sure that those deaths are investigated and that those children, even though we failed them once, let's not fail them again.
I understand. Yeah, I've had a little experience with this when we have these situations happen. I was a coroner for 18 years. I was involved with the coroner's office. My father was coroner for 40 years in my county. And I live in a great, unique situation where we have a great police force and a sheriff's office. So anytime something like that happens, I know that we will call and we assess that almost exclusively in a situation like what you described. GBI is called in by the local authority everywhere, whether it be the sheriff's department or whether it be the police department. So now I do realize there's probably some departments that get over zealous or whatever, but I feel like we have a pretty good system with our police and our sheriff's departments calling in, and they back us up. So making a mandatory thing of that, just automatic, because I do know that the GBI is pretty stretched thin too. We have to, through the crime labs and things like that. And I think Representative Crow, you know that too. So, and I'm sure Chairman Hitchens knows over his years. So help me get to where we need to be.
Well, I wouldn't be here if there wasn't a problem. And sitting on the state Child Fatality Review Board, there is a problem. And the problem for me is trying to, I'm just trying to solve the problem. I mean, I can tell you that there are deaths that aren't going to be ever indictments filed because, of poorly done investigations. And we can, it's like any proposal, we can sit there and throw rocks at it. But that's the truth. And if you think of a different way to get some subject matter expertise, I think it's superfluous. I have a city in my county that has 2 officers. And I don't expect them to be experts on child deaths. I don't expect somebody with a 20-man operation to be an expert on child deaths. They don't have forensic anthropologists. 2 of our medical examiners, bless you, 2 of our medical examiners are they have a double specialization in autopsies for children alone. We have the resources and we have the capabilities at GBI to make sure that this happens. I'm not saying that the GBI isn't going to turn it back over once, we're not needed here. Y'all have all the resources that you need. But there is, there is a necessity, I think, of, just giving them that first bite at the apple before evidence does get fouled up and before things do get messed up.
Yeah. I understand what you're saying there, but we pretty much do that anyway. I mean, we do. In my county, we do. In our county, we do automatically. If we go out and it's something that is grotesque or whatever you were explaining, it's automatic. We lock down. We keep everybody out of there.
And if
Coroner does not go in, move anything. The only thing that coroner says is don't move the body until we're there. So, and GBI is called in, they come in with their forensic team and whatever it is. We had a case where that happened. She was in her 20s, but brought in from another county, horrendous murder, shut the place down, got the GBI in there, the sheriff's department, GBI, the coroner's office, worked together to come up with a conclusion. And I'll tell you, we thought this was a terrible gang related deal. Comes to find out it was somebody that was trying to make it look like that. And within about 48 hours between the sheriff's department and the GBI, they had that case solved. So what
My question to you, if I
Yeah.
could interrupt.
Yeah.
Why would you, if you think that is best practices, why would you object to the codification or putting into law what you perceive as best practices?
I think we're already doing it. I think we're already following.
But why not put it in law if we are?
Yeah, I think it is law. I think when you have replicable offices that do the police and the sheriff's department, they realize that they don't have all those specialists that you were mentioning. So that's why we go to the state in the next level to get it done. So I'm just a little bit afraid that if every time we have a case like this, that it's like the local issue is out. I don't know if that's a good thing. I could be wrong.
I don't see the local, I don't see the locals
Yeah.
as being out, and I don't know why, if putting it down on pen and paper, what you yourself describe as best practices,
Yeah.
why that would be a bad thing.
We have a question. I want to hear Representative Crowe. Go ahead.
Thank you. Sort of to the chairman's point, on line 79 on the back, where it talks about the discovery of a victim that we're dealing with here, it talks about that the local law enforcement agency will provide notification to the Bureau. And again, the crime scene investigators and the investigators with the GBI are some of the best in the country. And we've never called them to assist us and not had them show up in the past. So it's nothing against them, but I do have some concern about the original jurisdiction part of it and giving them original jurisdiction. And I don't know if there's a way, maybe the lawyers who are smarter than I could figure out a way to codify this, but maybe not give original jurisdiction, but have it to where the notification is done to the Bureau and that they are required to be brought in to consult on something like this, but leave original jurisdiction with the local department. So that way you're going to utilize the local resources and the local department resources to do the investigation, which many times may be easier because they know people in that area. And a lot of times these crimes are not, they're not done by strangers. They're not arm's length type of crimes. And so they're going to know people involved in the local community that may be able to provide resources. So maybe that would be a way if that's possible. And I don't know if it's possible to have that codified like that, but if we could have that codified to where, we do make sure that GBI is notified and are requested or at least consulted on it, but maintain original jurisdiction with the local office and the local police or sheriff's office. That would be preferable to me, I think.
Okay.
And hopefully that would solve the problem that you're talking about. Because I do understand the problem you're talking about. It's just, I think that's in my experience, and you may know better sitting on the state board, that it's less common for that kind of stuff to happen than it is for what Chairman Mathis was talking about to happen, where we do call in the GBI and bring them in. So I think it's less common that happens. And so to codify this to make the entire state and all jurisdictions have to give original jurisdiction to the GBI I think would be a little bit of an overreach in my opinion.
Yeah, they already, enjoy original jurisdiction in a number of different, including drugs. So
Representative Allen, GBI, what was their statement on this?
they were comfortable with it.
Okay, Sheriff's Association, Police Association, where were they at on this?
I don't know where the Sheriff's Association officially
Yeah.
is. I know they would probably be against it just because, in working with them, they've usually been pretty against change.
Yeah. So I have one more question. Chairman Powell. I did it again. Chairman Collins.
Thank you, Mr. Chairman.
Good job.
I spoke to Terry Norris from the Sheriff's Association, got major pushback from them. My sheriff called me and asked me not to support this. And while I certainly understand where Chairman Ballinger is coming for this, I cannot support this in this current form. And I just found this out from the Sheriff's Association yesterday and hadn't had a chance to speak with you on that. But my sheriff, they do a great job. And I'd hate to punish, take away that original jurisdiction from every jurisdiction locally and put this on the GBI without having some more discussion and have some more stakeholders come to the table. I think we could probably keep it alive and deal with it over the summer and maybe talk about it next session.
Okay.
That's just my opinion.
Sounds good.
Thank you. All right, let's move on. I think we got a hearing only. I want to say one thing. Representative Ballinger, thank you very much for coming in front of us. Thank you so much. Chairman Hitchens, if you want to come about, and like you say, this is just a hearing only, and we have several folks signed up. So if you'll go right ahead.
I certainly didn't know it was a hearing only. I bring substitute House Bill 439 LC 39298 ERS. And as you can see, I said that it may be lengthy. Yeah, that may not be the case after listening to the last short case. But it's 37 pages long. And I tell you, I've read this a couple times and it's very technical. And I know I've done this. I spent 43 years on the State Patrol and I've worked at every level. I was a fatal accident investigator, started back in 1970 when we first started the program. I've dealt with fatal accidents. I've dealt with DUI laws and been over here testifying many times before when I was Minister of Public Safety about DUI issues. And there's always a significant interest by a variety of different groups. I think you probably have some of them online today. I've got a young lady back here behind me that wants to testify today who deals with it on a regular basis and probably has a lot more knowledge about this particular bill than I do. But the recurring problem with DUIs across this state, people are charged, they lose their driver's license, but they never stop driving. They get back in the car at the first opportunity, and if they have alcoholic problems, they're going to be drinking again, and they're going to hit the highway. And I know of no other way to stop them except with the ignition interlock system. And they've been doing it in other states for many, many years. Ohio, I went to a conference back in the 80s or 90s when Ohio started using it. They had a federal grant where they paid state troopers to sit down the road from people's houses who were chronic alcoholics, because they knew that when they got the opportunity, they were going to get back in the car and go. You've seen it being a coroner. A lot of it's horrific. I mean, you see little children, and I don't know why it happens like that, but typically the person who is intoxicated in accidents is the survivor. We've always talked about that at length. It just seems to me like maybe they're more relaxed when it happens than somebody that sees it coming and stiffens up. But I didn't have a bill this year. Former Majority Whip here, Ed Lindsay, approached me about carrying this, and I agreed. I had no idea it was going to be 37 pages and so technical. But anytime I have the opportunity to work and to try and deal effectively with driving into the influence issues, I make myself available. And I'd like to ask Ms. Pam Bettis, if she would, come up here. She's a Solicitor General in Henry County, and she deals with that on a regular basis. And she's had a lot of input into this law, and she and Ms. Doty over there, I think, have worked. This is the second iteration. I've already found a problem or two that we need to correct in here, and we're pretty open. We just feel like this is necessary this time if we're gonna stop this. I don't know how many of you know. I just checked the other day. We had the fourth largest amount of traffic deaths in the United States last year in Georgia. we're the 8th largest state. The only ones that were ahead of us were California, Texas, and Florida, who are all double our size. And many of those are DUI. I was telling Ms. Bettis a little while ago, back many years ago, Michigan State put out a study, and your chances of getting caught for a DUI were about 1 in 250. You can drive about 250 times unless you do something very foolish or you're very intoxicated and can't control your vehicle before you get caught. It's been reduced now. A recent study, she tells me, to it's about, you can drive 80 to 90 times before you get caught. So it's a significant problem. It's the same people that continue to do it. This is directed at them to make sure that the repeat offenders have a difficult time. They have to breathe in that ignition system, and it detects whether there's alcohol in their body or not, and the car won't start if there is. So it's costs a little bit of money. There's a provision in there for that too, but I'd like to call Ms. Bettis up here to say a few words.
That'd be fine, please, Ms. Betty.
Good evening. My name is Pam Bettis. I'm Solicitor General in Henry County. And before too long, it'll be good morning if we continue on.
Sorry, y'all.
The bill is broken up into several sections. So I'll just go over the sections very quickly because there are some changes that will make some noticeable differences. First, beginning on page 3, section 3, there's some changes to bail, and they involve the use of ignition interlock. So if you've never had a DUI before, you're stopped, you're detained, you're taken to jail, you have no history, then of course, no DUIs in the past 5 years, and you consent to the state administered test of your blood, breath, or urine, then you can be released from that custody on bail. Even in one section we talk about even on your license, and you complete a clinical evaluation, which is often, you'll hear it called in court as the drug and alcohol evaluation, within 30 days. And any other recommendations that they may put or bail conditions at that time. But where there's a big change is if you are arrested and this is your second of 5, which is a more dangerous driver that's driving under the influence, then you are required to complete the clinical evaluation. Your license is then suspended, and you are required to get an ignition interlock device at that time. So they can continue to drive, and so they can go to work, but they will have this ignition interlock on their car. There's an or in that section as well. If you refuse to submit to the state test, then you're also required at that time to get an ignition interlock and attend the drug and alcohol evaluation. And that's just the bail. That's the pre-conviction part of the changes to the DUI bill. Then on section 6, page 8, there's some changes to the wording. Individuals operating motor vehicles in the state do so on the condition that they will voluntarily consent to a chemical sobriety test, provided there's probable cause or where the individual has been involved in an accident and probable cause exists. So I know many of you are familiar that the wording has been implied consent. So there's an implied that you consent to a test of your bodily substances based on your privilege to drive. So changing the language to voluntary, we think is helpful. And in another section, there'll be a little bit more I can add to that. On section 9, page 11, that's where the post-conviction ignition interlock additions are added. So once you go to court and you are, say you plead guilty or you're found guilty after a trial, then you, as part of your driving, you would have an ignition interlock at that time as well. And then at a second offense, you would have a suspension for 12 months, but during that time, you could have an ignition interlock. Now for a second of 5, it's a 12-month suspension, hard suspension, and then 6 months of ignition interlock. So this gets a person already started with an ignition interlock in their car, utilizing that device, and they're still able to go to work, complete all of their treatment, do their community service, pay their fines, but they're required in the vehicle that they drive to have an ignition interlock device. There are some in Section 9, there were some concerns from GACTL as well as the Solicitors Association that there may be people that struggle to afford those additional requirements of the ignition interlock device. So you'll see in subsection E in Section 9 that there are some sections there that give a judge the ability to waive the requirement of ignition interlock. And some of those are if the conviction did not involve alcohol. So if you have someone that was driving on prescription pills, if you have someone that's driving under the influence of marijuana, someone driving under the influence of inhalants, then obviously an ignition interlock would not help, would not be a good treatment or punitive use of the ignition interlock for them. If the person doesn't own a motor vehicle, say they just happen to get a vehicle that belongs to somebody else at the time they got their DUI, but they no longer have access, it got impounded and they never were able to get it out, then it wouldn't be a good idea for them to have an ignition interlock. That's a hurdle that they can't complete. If the person is unable to pay for the device, but with a reduced fee voucher, they can get it, then there's a section in there that allows a judge to say, hey, give this person a reduced fee voucher so that they can have the item installed and then pay a lower monthly rate. And then finally, there's a section in there for someone that just still cannot afford not only to have it installed, but can't afford it with a reduced fee voucher, that a judge can hear that evidence and make a determination and a waiver. I think the young lady from DDS is going to speak because we do have a section that we believe probably should be amended, and I can get to that requires DDS to assess financial ability. But that's something that we can move to this section if the committee prefers that, for a judge to assess those things that are in that section. Then over in section 11, page 16, there's a section, any person whose license was suspended as a result of a first conviction within 5 years may apply immediately for the ignition interlock device permit. Of course, they'll have the IID ignition interlock device, plus they'll have that permit that allows them to go to work, school, and medical. This section also includes an A5 that the department will not or shall not issue an ignition interlock device driving permit to persons whose license is subject to suspension because they failed to abide by the conditions, say they didn't complete their clinical evaluation. Also, they shall not issue an ignition interlock device to anyone who is seeking a permit pursuant to those bail requirements that required them to get, again, the clinical evaluation. In this section, there's also C1B, the department shall issue an ignition interlock device limited driving permit for a fee of $25 and proof of conviction or eligibility and surrender of traditional license. And then C3 in section 11 talks about upon request, the department shall determine financial hardship. That's the section that I was telling you about that the committee may prefer to move that after the young lady from Department of Driver Service speaks over to subsection E in section 9. Then page 22 begins section 13. That's where we have the additional change in the implied consent warning, which is changing the wording from implied consent to voluntary consent. And that's for each of those sections. That's for those drivers that are under 21, those drivers that are over 21, and those commercial drivers. There also is a change in subsection B 1 through 2 that changes the wording that the license will be suspended for a minimum 1 year to the license may be suspended as a condition of your bail. And then G4 is a section where it removes language relating to the requirement to maintain the limited driving permit. And then in section 17, page 32, this is an extremely important part of the bill, particularly to the Solicitors Association, because we haven't had this access before to the ignition interlock device data. So I think most of you know ignition interlocks have been around for a very long time. I think they were first on the scene back in 1970. One of the studies I read stated that the first ignition interlock was used that year. And that was a really good year. That's the year of my birth. So the first IID came along. And so we've never had access as prosecutors or the court or probation officers to this data so that we can track. Because you know this section also has it as a misdemeanor if you tamper with the ignition interlock device. Or you have someone else blowing into your ignition interlock device. So section 17 on page 32, the ignition interlock device companies have agreed that they would make that data available to prosecutors in the courts and probation. And then that way, you know, a probation officer or a prosecutor can track that. And if we see that what is supposed to be a very helpful treatment option that, you know, allows a person to, you know, get onto the road, get to their jobs, get to their schools, keep their family intact financially. You know, if they're violating that, then that gives us a chance. We can say this treatment option isn't working and you're taking it for granted, and we can take action. Section 18, page 32, ignition interlock devices and all registered cars. I think that the young lady, Miss Maisie, will speak to this from Gactyl. We noticed after we talked this morning, there may be a problem there. The initial wording in that section was that all registered cars of that violator would have to have an ignition interlock device. And after talking with Gactyl, she had a good point that you may have, say, a mom or a dad who obtained a DUI. They're required to have an ignition interlock device, but they have 3 or 4 cars registered to them, and 2 of those cars are being driven by college students that are in school across this state or out of state. So that language we may want to amend to, and we do have a fix for that, to state that any and all cars that they are subject to drive. And so we can fix the wording that says if they are driving a car, it has to have an ignition interlock device. There's also a section that allows the person, if they're continuing to finish up parts of their sentence, that they can have their permit renewed for an additional 2 months, and reiterates that NOLO is a conviction. And then finally, section 20, page 36 provides providers must install the ignition interlock devices at no cost upon presentation of a fee waiver. Any person with a waiver shall be charged a reduced monthly monitoring rate at half the normal rate. And any provider that does not comply will face a fine themselves. So that's kind of going over the bill in a really quick nutshell. Is there any?
That was a very, very good job. Thank you. I was glad you brought up that part of somebody else breathing in to it, because I heard that just recently that happened. A mother, I think, that had a problem, had a child.
Well, they've made so many advancements in the ignition interlocks.
Yes.
I think some of them even take pictures now and have videos. And they also added features where they can require you, after you've started the car and you're driving for a certain time, to blow into the machine again. So let's say a violator is at a bar and they have a friend who isn't drinking come out and blow in the machine, and then they leave, and their car may stop until they blow again. And then if they register, there's certain things they have to do through that company to get their car to crank back up. So they've made a lot of advances. I think the company could speak a little bit better to that. But it's not like it was in the 70s, though. That was a really good decade.
Yeah, well, that was, this is good. We need to do something about this. I agree. And I thank you so much, Ms. Betty. Who else we got to speak? Okay, well, let's go with Mr. Lindsay. Is he still with us? Yes, sir. You're up.
Thank you, Mr. Chairman.
Before you start, Ms. Lindsay, Representative Crowe had one question here.
Sure.
Go
Yeah,
ahead.
I'm sorry. I could have waited until we got
No,
done.
that's all right. That's all right.
Because, I mean, Solicitor Bettis has already sat back down now, but,
She probably don't mind getting up as much as they've been sitting in.
so the now voluntary consent notice, which is no longer implied consent, should this pass, it talks about their license may be suspended. And just so I'm clear, is the former administrative suspension and the hearings that were had, is this replacing that in lieu of, in addition to, another option for? Are those administrative suspensions still going to be?
Well, throughout the bill, you'll notice that
I saw a lot of stuff.
the administrative suspensions are crossed through.
Okay.
And with these bail requirements in there,
Mhm.
I don't know that you're going to need an administrative license suspension as much as you would before, because if it's your first, then you can get automatically an ignition interlock permit and drive to work. If it's your second, there is a suspension period, but then you can apply to get your ignition interlock. So
Okay.
I don't know that you're going to need the admin hearings as much.
Now that's actually good. I'm good because that's, I don't know that they were as effective as they'd hoped to be. And I know that a lot of officers had a hard time getting to some of the hearings sometimes, and
That's probably good
it
for law
essentially didn't
enforcement,
happen. It essentially, the license never got suspended because officers weren't able to make it to the hearings when they were scheduled a lot of times. So I'm glad to see this as an alternative. So,
Yeah, it was an additional requirement for the officers that was exhausting. Now, there's still a requirement to read implied consent. So and I didn't delve into that part of the bill as much. So there may still be a need, but we may hear from the administrative law judges. So it's good for the officers. I don't know if it's good for the administrative judges.
Thank you, Representative. All right. Come on up, Mr. Lindsay.
Thank you. Thank you, Mr. Chairman. I'm going to be very quick because I know there's several people that wanted to sort of testify via Zoom who have worked very hard on the DUI issue and trying to cut down on the carnage on the roads. My name is Edward Lindsay. I'm a partner at the firm of Denton's, the law firm, and I'm the head of the public policy team. I'm also here today representing the Coalition of Interlock Ignition Manufacturers. Usually as a lobbyist, I wait for folks to come to me. This is one situation where I went to them, and because I've worked on DUI issues, both when I was in the General Assembly and later for very personal reasons. You will notice that as I've grown bald, there's a dent in my forehead that becomes more and more pronounced. That's because at the age of 2 years old, someone who was drunk crossed the center line and hit my mother head on, and I went through the windshield. It's been apparently several months in the hospital. Fortunately, I don't remember too much of that, but it did endanger me, and it did bring home the dangers of folks who drive drunk. And we have worked on this bill quite hard with the prosecutors. I have made pledges, and we have made pledges. The chair carrying the bill, as well as other folks who are proponents of the bill, to continue to work with the defense lawyers group, DDS, and of course the prosecutors who've worked so hard with us to put together this proposed committee substitute, should you allow the bill to go forward today, which we would certainly hope that somehow we could arrange for a way to do so, because the carnage of the road on the road will not cease until we start taking steps that don't just make us feel good, but actually will make a real difference. And as Chairman Hitchens laid out, based on his experience, this is one of the few things that actually changes behavior and cuts down on the carnage on the roads. And so what we would simply ask is that if it is possible for us to move forward, we would certainly ask to do so. If it's not possible for us to move forward, we will continue to work on this issue and get this issue passed, because the problems will not go away. And we sincerely thank the committee for its time. And I want to turn it over now to the people who I know who are on Zoom, who have worked with this issue diligently, from MAD and other groups who've seen firsthand the problems that we have in this country, particularly the problems we have on the roads here in Georgia. Thank you, Mr. Chairman.
Thank you so much, Mr. Lindsay, for that. We do have a couple others, I believe, on Zoom. We'll go to Frank Harris. Are you still with us?
Yes, sir. Yes, Mr.
Go
Chairman.
right ahead.
Hi, Mr. Chairman. Thank you for having me here. My name is Frank Harris. I'm the Director of State Government Affairs for Mothers Against Drunk Driving. William, be quiet. Sorry, my son's in the background. And this is the first time we've been on the same side with the solicitors on this issue. We have fought the solicitors on this issue many times in the past, but it shows that this is such an important issue. And this is MAD's top legislative priority. It has been since 2008 when in Georgia. And we've been supporting ignition interlocks as for all drunk drivers because it is the only tool that can physically stop somebody from driving drunk. And we've been making this our top priorities nationally since 2006. The reason why we did this is because we were doing a whole bunch of other things, fighting for license suspension, fighting for increased penalties, fighting for jail for non-injury offenses, and it wasn't moving the number of drunk driving deaths down. So in 2006, MAD launched our campaign to eliminate drunk driving, which is, again, focusing on ensuring that more offenders use an ignition interlock, because an ignition interlock is the only tool, as mentioned, that can physically separate someone from driving drunk. And according to the CDC, these sort of ignition interlocks is 67% more effective than just license suspension alone. And you know, license suspension really is a hope for the best approach, and we can't use hope to eliminate drunk driving. And in Georgia, it's been mentioned the use of these devices. They're currently mandatory for repeat offenders, optional for first offenders. This proposal goes a long way in improving the use of ignition interlocks. It's mentioned that there's an indigent program, so for those who can't afford the device, to get it at a reduced rate. And it should be noted, majority of states have some sort of indigent program in their law, and not one of those has been ruled unconstitutional. So, you know, when MAD first started pushing for ignition interlocks, there was only one state that had a law like House Bill 439 in place. That was New Mexico. Now we're at 34 states that have laws like what's before you all today. So there's been 34 states that have taken action, 33 states that have taken action to enact these sort of laws. And we've seen dramatic progress in the fight against drunk driving over the last 13 years that MAD has been pushing this. And specifically, you know, the Insurance Institute for Highway Safety, they found that laws like House Bill 439 reduces drunk driving deaths by 16%. And also MAD ourselves, we were curious, how many times have these devices actually physically stopped somebody from driving drunk or drinking and driving in our country over the last 13 years? And what we found is alarming. Over the last 13 years, ignition interlocks have prevented over 26 million attempts to drink and drive on our United States roadways, including 3.4 million attempts to drive drunk with a 0.08 BAC or higher. And in Georgia, if you just want to know the data, even with the limited law that's in Georgia right now, ignition interlocks prevented over 300,000 attempts to drink and drive in the last 13 years and 40,000 attempts to drive drunk. So there, you know, nationally, there's been a dramatic reduction in drunk driving deaths since MAD has pushed for ignition interlocks. It's gone down by 25%. These devices work. We've been pushing hundreds of laws over the last 13 years, and we've seen a 25% reduction in drunk driving deaths. And we've been working on Georgia since I've been with MAD for 13 years. And this bill is so close to getting something done that could save a lot of lives and help turn the tide against drunk driving in Georgia. So I thank you, Mr. Chairman, and we urge a favorable, once this is voted on, to be advanced, because this is too important to hold another year over. Thank you.
Thank you so much. Do we have any questions? I don't see any, but I sure do appreciate that. And I do agree with what you're saying. Thank you very much. I believe we have one more online. Is that correct? Two more? All right. Alex Oak, is that right? Can you hear me?
Yes, can you hear me?
Yes, go right ahead.
Thank you, Mr. Chairman and members of the committee, for allowing me to testify today in support of House Bill 439. My name is Alex Audie, and I'm the national president of Mothers Against Drunk Driving. When I was 13 years old, I was run over by a drunk boater. I was sitting on a jet ski behind my dad's house on Lake Harrington in Danville, Kentucky. I was sitting across the lake about 40 yards from my mom and my brother as they were docking our boat. I was waiting for them to finish so that I could dock the jet ski and we could go up to the house. There was a 17-foot bass boat coming under a nearby blue bridge. I gave my mom a thumbs up to tell her I saw him coming and I wasn't going to move. The boat was headed towards my mom and my brother. My mom screamed. The boat banked it to the left and never straightened up. He hit me from the side going over 60 miles an hour, threw me off the jet ski. The boat went up over the jet ski and came down on top of my body. I sustained very severe injuries, including a traumatic brain injury classified as shaken baby syndrome. I suffered a broken jaw, a broken neck, a broken collarbone, a lacerated liver, and bilateral shattered femurs. I now have metal rods in place of bone in both of my thighs. When the boat came down on top of me, the propeller landed on my legs. My left leg was under the water just enough that it only required stitches, but my right leg was severed by the propeller. The man who ran me over was 3 times over legal limit, 2.5 hours later. Months later, I sat in a wheelchair in a courtroom as the man who changed my life forever denied any wrongdoing. He was charged $250 and left to walk out and reoffend, and he did, multiple times. I've had 8 emergency surgeries in the first 7 days, and so many more in the years since. I spent a week in a coma, several weeks in the ICU, a month in a neck brace, and several months in a wheelchair. To no fault of my own, this was my new life. The only thing that would have changed that crash is if he hadn't been drunk. House Bill 439 would put life-saving all-offender ignition interlocks in the cars of drunk drivers. Mothers Against Drunk Driving supports this legislation as it is an improvement to the impaired driving law and will hold accountable those who continue to make this deadly choice. Mr. Chairman and members of the committee, MAD urges you to please advance House Bill 439. Thank you.
Thank you for that testimony. Do we have any questions? All righty, thank you very much. Let's see, we have one, is it one more? Chris Conshank, did I say that right? Is that on Zoom? Are you there, Chris?
Yes, I am.
All right, you go right ahead.
Good evening, Chairman Mathis and distinguished members of the subcommittee. I appreciate the opportunity to testify before you today in support of House Bill 439, which would expand the use of ignition interlocks and save lives. I'm Chris Conshank, Senior Director of Government Relations and Traffic Safety at the Foundation for Advancing Alcohol Responsibility, responsibility.org. We are a national not-for-profit that helps lead the fight to eliminate drunk driving and underage drinking and is funded by the following distillers: Bacardi, Beam Suntory, Brown-Forman, Diageo, Edrington, Mast Jägermeister, Moet Hennessy, Old Smoky, and Pernod Ricard. Currently, 34 states in the District of Columbia require ignition interlocks for all DUI offenders. Georgia is one of the few states in the nation that does not have a mandatory all-offender ignition interlock law. Simply put, ignition interlocks are one of the most effective countermeasures available to stop drunk driving. Ignition interlocks are highly effective in reducing recidivism among both repeat and first-time DUI offenders. While the devices are installed, interlocks have the most potential to reduce recidivism and change behavior when paired with other effective interventions such as assessment and treatment. Please consider these research highlights. A recent study commissioned by Centers for Disease Control and Prevention that involved a systematic review of 15 peer-reviewed studies on interlocks revealed that while the devices are installed, the rearrest rate of offenders decreased by a median of 67% compared to groups who never had an interlock installed. A study of New Mexico's interlock program found that first offenders who participated had a 61% lower recidivism rate while the device was installed and a 39% lower recidivism rate following the removal of the interlock compared to offenders who never installed the device. Results from a survey of DUI offenders required to install an interlock in Santa Fe, New Mexico, reveal 87% felt the interlocks reduced driving after drinking. Furthermore, 85% of the offenders thought that the interlocks were fair to DUI offenders, and 67% believed that all convicted DUI offenders should be required to install the device. Thank you for your efforts and leadership to reduce impaired driving in Georgia. We urge your swift passage of House Bill 439 into law this year. It will prevent DUI, reduce crashes, and save lives. Thank you.
Thank you so much for that testimony. Do you have any questions? Do y'all have any more statements you need to make, Chairman Hitchens?
I only want to make one, and that is I want to thank Ms. Bettis. She's supposed to be off camping today. She's off and she spent all day up here testifying for a few minutes. She certainly didn't know this was going to be for a hearing only. I mean, nor did I.
Well, that's what we were instructed, that it was a hearing only. And so at that, if there's no other comments.
Chairman, I had asked, this is Ms.
Yes, ma'am.
Causey. I'm sorry, this is Ms. Causey from Gactel. I had signed up to testify, but if you prefer me to waive off until the next.
Sorry, I missed that and it's my bad. You go right ahead if y'all don't have a problem with that. Okay, go right ahead.
Thank you, sir. House Bill 439 is an attempt at increasing financial profit for private companies at the expense of due process for Georgia citizens. Driving under the influence of alcohol or drugs is one of the costliest offenses to resolve in our courts. Notably, Georgia DUI conviction rates have been steadily falling since 2007. Back in 2007, Georgia processed over 40,000 DUI convictions. In 2019, that number was down to 19,208. So certainly there are mechanisms in place that are decreasing DUI in Georgia without having to have this broad application of ignition interlock devices. The programs and services that are necessary to enhance public safety with respect to DUI should be as affordable as they are beneficial. We would like to let the subcommittee know that our membership expects that you will see an increase in DUI trials because of the enhanced punishments and punitive measures currently laid out in House Bill 439. We are certainly appreciative of being brought into the conversation today by Mr. Lindsay and the Solicitor Generals. We think there's a lot more conversation to have before this bill is ready to move forward. There are, it's also notable for this subcommittee to know that the data is not current, and of course it's difficult to get data sometimes, but for the 5-year period between 2007 and 2011 in Georgia, the recidivism rate following a first conviction for DUI was 33%. We have several concerns about the legislation with respect to cost. The most basic ignition interlock device is going to cost someone about $1,100 for the 1 year that is typically prescribed. So a 12-month, if it requires 12 months of supervision on an ignition interlock, it's going to be about $1,100. If you extrapolate that a cost over to the 19,000 convictions that I mentioned earlier, in 2019, that would have resulted in $20 million worth of fees being paid to the IID providers by the people under sentence in our state. We are appreciative that the sponsor has heard some of our concerns about the financial hardship aspects of the bill, and we see that there are some provisions being made for financial hardship for people that are facing DUI convictions in our state. We also appreciate the change that was mentioned earlier, wherein only the car that someone actually drives would be subject to an IID. We see that right now the language is much more broad than that, and we appreciate that narrowing that it sounds like people are open to considering. We would also encourage you to consider an exception for those who have to drive company vehicles. I'm sure that you can appreciate the loss of employment without any due process is a concern at any time, but especially now with the economic impact the pandemic has had on our economy. There is language available in the federal code that we would recommend in this regard. The federal code allows for an exception when the individual is required to operate an employer's motor vehicle in the course and scope of employment. and that the business entity owns the vehicle, that it's not owned or controlled by the individual. Of course, that would be subject to the IID. We would also encourage consideration of an exception for those people who live more than 100 miles from one of the IID service providers. To have to travel more than 100 miles each month is a much higher burden than someone should have to bear. It is our understanding that these check-ins don't typically result in any kind of actual service to the device, but they are a means of keeping tabs, which I can understand why you'd want to have that oversight. But if someone has to travel more than 200 miles round trip to make that happen, it's onerous and burdensome. We are most astounded by Section 3 of this bill. The implications of Section 3 are incredible. For instance, if someone refuses a chemical test on their first DUI offense, let's say they're in Fulton County, given that court's timelines, they would likely be subject to pre-adjudication license suspension for as many as 2 years or more, with only the possibility that a judge would issue one of these ignition interlock device limited permits, because it is discretionary in the bill. The bond conditions that are set up in Section 3 of the bill effectively shift the punishment that we normally reserve for post-conviction once someone has been adjudicated guilty of a crime into the pretrial structure of our criminal legal system, without any due process, without any finding of guilt, at the time when people are presumed to be innocent. We also understand from some of our contacts at a local court that the 30-day timeline for the drug and alcohol evaluations contemplated in the bill is unachievable at this time. As you might imagine, those types of programs sometimes have wait lists. I'm sure there's a reasonable way to work through that timeline with the other stakeholders, but we wanted to bring that to your attention. The courts just may not be able to meet the timelines that are laid out in Section 3 at this time. The other concern we have about the pretrial use of ignition interlock devices is there's not a clear mechanism in this bill for the removal of the device. So for instance, the timeline that someone would require the IID may be much shorter than the time that's required for them to get to trial, but there's not a mechanism in the bill that would allow removal of the device once, for instance, that 6-month period of time has lapsed. So we would ask that there be a provision to make clear that once someone has served the entire 6 months, that they can have it removed and they don't have to continue to use it during waiting for the pendency of their case to be reached by the courts. And this was mentioned earlier. We don't have any concern about the Department of Driver Services being involved in the undue financial hardship decisions. It's my understanding that they might have a concern about that, but we do have a concern about the way the income provisions are laid out in the bill. We would recommend that those levels be laid out so that they match other parts of our code that impact indigent folks in our criminal legal system. There are some code sections in Title 42 and in Title 17 that already lay out a structure that the courts use today to determine financial hardship situations. And we would recommend that those be included here too, so that you're not subject to one scheme for, say, for instance, obtaining a public defender, and another scheme, for instance, for obtaining a financial hardship exception to this IID limited permit. We were glad, like I said earlier, to have received the substitute bill today and had a chance to look at it today. And unfortunately, most of our practitioners that handle DUI cases have not had a chance to weigh back in with us. So these comments that I'm bringing to you are somewhat abbreviated. We would love to have the opportunity for not only our practice area experts to review this bill more thoroughly, but to sit down with the other stakeholders, the prosecutors and the IID companies, to have further discussion about this bill. I feel certain we could reach some compromise, but not if we can't all sit down at the table together. So maybe by having a hearing only opportunity today, we'll have a chance to do that. But until then, we would have to oppose this bill as it's drafted right now. Thank you for hearing from us today so many times, Chairman. You've had a lot on your docket that's in our wheelhouse.
Thank you so much, Ms. Causey. Does any committee member have a question for Ms. Causey or a comment? Do any of y'all want to respond to anything? No, ma'am, I don't think we do.
Okay, thank you so much. Have a good night.
Thank you. Do we have any other discussion, anything? All right, I'll have a motion to adjourn. If we're not, got it? Second, we are adjourned. Thank you very much.